Hello, everyone. This is Sri Janata with Journey Financial Strategies in Oklahoma City. We're a financial planning team. We serve Oklahoma, Texas, Midwest area. We also have clients across the U.S. So today, I want to talk to you guys about basic estate planning and why it's important. We're going to interview our good friend, Mitch McQuistion. He's with Evans Davis. It's a boutique estate planning and business transactional firm. They serve Oklahoma and Midwest, but they also have offices across the U.S. So thank you, Mitch, for being here today with us. I'm going to ask you some basic estate planning questions. I know you guys do some pretty advanced stuff. That's one of the reasons we enjoy working with you guys so much, is that you can serve our clients that have pretty decent estate all the way to the biggest estates that you could think of.
Well, the number one thing I always say, Sri, is that whether or not you have an estate plan, it's just a matter of if you wrote it or you let the state write it for you. So that's a deciding factor there.
Yeah, very true. So everybody's got a plan. It's just a matter of who wrote it.
That's right.
That's good. Mitch, tell us just what basic estate planning is. You know, there's a big confusion. Everyone says, oh, well, we have a will. And then whenever we talk to clients about making sure that they have a trust plan, they're like, oh, estate planning, I'm not that rich. So if you can kind of take us through the difference between having a will versus a trust and what an estate plan is.
Sure. Well, estate plan in the most basic form is essentially the documents that govern your financial affairs, that says what happens when someone becomes incapacitated, what happens when someone passes away, and what are the rules and provisions for how that occurs and when that occurs. And so I think one of the most common things that are misconstrued is people say, well, I'm not wealthy, I don't need a trust, right? That's a big misnomer. And, I think there's a lot of misinformation out there about wills and probate and trust. And so I think the number one thing is when we watch TV shows and someone dies with a will, everybody just hugs and moves on down the road, right? That's actually not true. When someone passes away without a will, the traditional manner is that they still go through probate depending on how the assets are titled. So I think the number one thing that people need to understand is even if you have a will in place, that you still go through the probate process.
Different states have different limits. I've heard of some states being probate states and some not. What is about the size of an estate where a person should be like, okay, I need to get a trust in place? Yeah. Is it $1 million? Is it $2 million? At what point?
Actually, Sri, that's a great question. I think a lot of people are going to be surprised by my answer to this. There's a little bit of variable by each state, but a general rule of thumb is about $75,000 in owning real property. So as a general rule of thumb, you can probably say if you own a piece of real property and have more than $75,000 of assets, you should look at some form of a revocable or living trust.
Why would someone create just a basic will? Is it just from lack of understanding?
I think it's lack of understanding, and I think sometimes the funding of the trust can be a burdensome task. And when we use the term funding a trust, that means putting the real property into the trust, the bank accounts into the trust, and making sure that the assets flow through it. And sometimes law firms simply don't do that. So I think a good takeaway is that if you're working with a law firm to set up your estate plan, you need to make sure that they're willing to fund the trust for you or help you through that process.
Now, that brings up a great question. I'm kind of going out of turn here, but we've seen clients walk in with trust documents. However, their bank accounts are still owned by them. Their home is owned by them. Their investment accounts are in their personal names. Did things just happen differently back in the days when attorneys didn't fund the trust?
Well, to be honest, being a partner at a law firm and owning a law firm, some of the hardest work sometimes with the trust is the funding aspect of it. It would be much easier for us just to say, here's your documents, good luck. But we spend a good majority of time working on beneficiary forms and deeds. And so there is a lot more legwork. And I think maybe in the past, people try to take a shortcut, or they got a plan in place and they just never updated it, meaning they bought a new house or opened new accounts and they just never incorporated the trust with those new assets.
Okay. So why is basic estate planning or basic trust planning important? What are all the different reasons why somebody should do it?
Yeah, there's a lot of good reasons why you want to do basic trust planning. We want to avoid probate. We potentially want to get a stepped up in basis and the value of assets at the time of death. We want to make sure that there's protections in place and rules in place that if a couple is married and one of them passes away, what's the rules for the survivor? And then ultimately, when we pass the assets to the beneficiaries, we need to make sure that we have rules in place to protect them. Sometimes our beneficiaries have bad marriages or a creditor issue or an outstanding tax lien, or there's a multitude of reasons that when we pass the asset to our beneficiaries, we want to make sure that our family benefits from it and not a third party.
Yeah. I always say trust planning allows you to dictate who gets what, when, where, how. So that control is very important when you're talking about your assets.
Even, Sri, on that note, a lot of times it's not so much the control aspect. It's when a beneficiary inherits it, we want to make sure that it benefits our immediate family and our grandkids, not a divorcing son-in-law or daughter-in-law or creditor. And so I think sometimes maybe it's not so much the control, it's just we want to make sure that what we worked hard for our whole life is protected. Whether you're married or single, I'll also say this, and I say this a lot in meetings, is, as difficult it is to understand, your marriage is going to end in one of two ways. Your marriage is going to end in either death or divorce, right?
Yeah.
And so, we need to have a plan in place so that when your spouse passes, we know what the provisions are. And then when both of you are gone, how your family or your beneficiaries are going to receive that.
I'm glad you bring that up. We're lucky enough to work with some very successful young individuals that are not married. Yeah. Or some individuals that, even if they're not young anymore, they may never get married.
Sure.
Why should someone that doesn't have any kids or isn't married or isn't planning to get married, may have some nieces and nephews or some distant family relatives, why should they have a trust?
Yep. So it's a great question, Sri. Sometimes planning isn't just because you have kids or things of that nature. I mean, the number one thing that I want people to fully understand is that probate is a judicial process that is relevant in every state. And every state might have a little bit different probate rules, but when someone passes away, whether or not they have kids, if they don't have a proper plan in place, they're going to go through probate. And with COVID and the lack of sitting judges currently, probate process is taking anywhere from 9 months to 2 years, and it's public, it's expensive, and it's inefficient. So I think that's a great reason for any person, whether or not they have kids, to have a trust in place.
So it's fair to say that's exactly why you need a trust?
Yeah. Okay. Yeah. Getting a court hearing today is taking, probably 45 to 60 days just to get the first hearing. So wow. That shows you how inefficient, the system is.
Yeah. So what are the different types of trusts that are out there? There's all kinds of acronyms, and there's quite a bit of confusion because we have clients that just throw, lingo out left and right as if they know what exactly they need.
Sure. So I think it's very important for everyone to know that when someone says living trust, family trust, or revocable trust, that's all one and the same. That's what we call a grantor trust, and it can be amended, changed, or updated over time. And then there's also irrevocable trust. Inside of irrevocable trust, there's probably 10 to 20 different types of irrevocable trust, like life insurance trust, gifting trust, all sorts of different ones. So from a more basic tense, there's revocable and irrevocable, but underneath each of those umbrellas is a whole umbrella of things.
We have a lot of business owner clients. That's a big part of our client base. What happens if that's not in a trust and a business owner passes away?
Well, legally, you are not supposed to carry on the affairs of the ownership or the business until you get a court order appointing someone as the executor or the administrator of that estate. So that's really important because if we have accounts receivable, payroll, benefits, or even rent payments, right? Those things cannot occur until a judge appoints someone with the authority to do that, right? In the alternate, if a business owner's ownership interest is owned by a trust, the successor trustee can step in immediately upon incapacity or death and step into those shoes and carry out the business. A prime example would be about 3 years ago, we had a dentist and he passed away. The value of the dental practice went from about $1.8 million to we sold it for $600,000 because we had to close the doors for 60 days.
Wow.
Right? Because that's how long it took to get a court order. And so that's just a prime example of why it's important to get that done.
You mentioned something earlier, Mitch, about revocable trusts. I've heard this often where someone says, well, I'm not ready to give up control. I don't want to do a trust yet. I don't want to put everything in a trust. I want to be able to control it. Obviously, there's a lot of misconception there.
Yep.
Please talk to us about how much control a person has once they set up the right type of trust, a revocable trust.
Yep. When you are setting up a revocable trust and you're what we call the grantor, meaning you're the person who forms the trust, you're allowed to fully be in control while you're alive and you're of sound mind. So my analogy is always, you're still the quarterback, you're still the one driving the bus, you get to decide what goes in the trust, you get to decide what gets pulled out of the trust, you're fully in control. That's a little bit different most times when we have irrevocable trust, where you're basically placing assets into that irrevocable trust and having someone else be the trustee.
Yeah.
So I think that's really a really great point is if it's a revocable trust-based plan, you're still in control. You don't answer to any third parties.
If I was ready to move forward and set up a trust, how do I start?
Yeah, absolutely. Depending on if you were working with our law firm or any other law firm, a lot of times we're going to sit down for about 30 minutes to an hour and run through family dynamics, assets, spending habits, creditors, and then ultimately devise, kind of a game plan on what is the best fit for you. And then at that point, we figure out, what's our timeline to complete the project and what are the fees associated with that. And so that's probably the best way to go about it.
Mitch, we've obviously worked on with a lot of clients with your firm. We have other attorneys that we worked with in the past as well. One of the things that I really appreciate about how you handle your process, and the reason we trust your firm to handle our clients well, is you have a very defined process to where I feel like the trust planning gets done fairly quickly. Mm-hmm. We've had clients in the past. This was actually probably before. This was 7-8 years ago before we started working with you guys more. We had a client, it took over 2 years for this client to get a basic trust document in place because their local attorney who's always helped them set up LLCs and things like that, he didn't do it every day.
Yeah.
And he was more or less a one-man shop, had an assistant, and he eventually brought in another attorney, and she ended up completing the task. She did great. Yeah. Now, it still took a little bit longer than how you guys do it, but ultimately, if the end product is the same, why is it that some firms take so much longer than others?
We spend a lot of time and energy on efficiencies, and at the end of the day, we practice what we preach in terms of having a succession plan. So when you work with our law firm, you're not working with just Mitch McQuistion, you're working with the team of people around me, because if Mitch is out on paternity leave, or if Mitch dies, or if Mitch is on vacation, it's important that the ball continues to move in the right direction, because this plan is bigger than just Mitch or one person. And I think that says a lot about the firm you hire and why you want a team around you to do that.
Okay. Once I get the trust put in place, how do I communicate that with my family?
Yeah.
I have a big binder sitting under my bed. How do they know where to go and what to do if something happens to me?
Yeah, that's a great question. I think there's two approaches to that topic. One is sitting down with the beneficiaries when they're mature enough and maybe verbalizing in a family meeting, here's the assets, here's how we structured it, and here's what that looks like, right? Some families prefer that. Other families say, hey, I just want to make sure the successor trustee knows where it's at and that they're named and they're in control. So sometimes just verbalizing or relaying the message that it's done is important, but sometimes I think it's powerful to have a family meeting to really explain it.
Yeah. All of our clients, we encourage them to introduce us to their children. Sure. And their successor trustees, as well as, keep all of their legal team and their accounting team, keep all their business cards in that folder so their family member knows how to get a hold of them.
That's good advice.
Finally, a lot of our clients come in and they're like, oh yeah, we did a trust about 5 years ago, 10 years ago, and hadn't been reviewed. And we've seen some trusts that just, they were just empty. First of all, like they still hold, unfunded.
Okay.
And these documents, there's a lot of things that have changed.
Yeah.
We say, life is a motion picture. It's not a snapshot. So how often should a client review and update their trust documents?
I mean, you just saying that's a motion picture. It's continually changes. If you look back 5 years ago, your life today is much different than it was 5 years ago.
Absolutely.
And so it's continually changing and evolving, just like your assets are probably going to continually change. So I think it's important to review your trust because, what if you inherited assets? What if the family dynamic had changed? What if the asset had changed? And then, guys, there's a lot of tax rules and provisions that also always need to be considered. The Secure Act, for example, that was passed a few years ago, that really changed a lot of charitable planning and distributions, right? So where people used to leave money, a lot of money to charities through the trust, well, now with the Secure Act, we're completely changing how those distributions might occur. So things are ever evolving, whether that's on the personal level or the tax and legal level.
If you're working with the right team, that team should take that complication out of that equation, make things as smooth as they can go. I think when you have good guidance from the right attorney, they will guide you to get this stuff in place without having too much of friction where you just get delays and prolongs the process. So the way we work with our clients, we first sit down, have many lengthy conversations. We'll discuss your objectives from both a personal, business, and an estate perspective. Put together a plan of action and get you to move forward. We'll, based on your specific needs and your personalities, we usually have a few attorney recommendations. And with that, we'll just, we usually like to make the introduction to the attorney or the attorneys and let the client move forward and setting up that appointment with them. And we're even there, we're involved. I mean, we've sat down with clients a few times, many times actually, together as we're helping put their trust documents together. Clients have at times they have a hard time describing exactly what they want happening. We have different dialogues and you have dialogues with them. And when you sit down with them, the client may feel maybe under the gun and not be able to get responses to you right away.
Sure.
Because we've already gone through some of the stuff, we can say, well, hey, we talked about this. How do you feel about this? We can usually prepare them ahead of time so they're better prepared for the meeting with you.
Absolutely.
You guys have done an incredible job of funding the trust. We've often been involved with funding the investments and insurance policies and things like that. We've done that for them. So we really, really appreciate how much you guys do. This is what we enjoy. This is what we're here for. So if you want to learn more about how we can help you put together not just a comprehensive financial plan, but get the process started and getting your trust established, we'll have conversations. If your estate is large enough, or if you have unique goals and objectives or needs, we will point you in the right direction and be with you during the entire process until it's done. So, Mitch, thanks for joining us today.
Thanks for having me. Really appreciate it.
Yeah, absolutely. Hope you found this to be informative, and we'll see you at one of our next videos.